in court. This is the judgment of the court. In this appeal, the appellant, Moses Kasaine Lenel Kulal, who is the governor of Samburu County, is aggrieved by the decision of the High Court, which upheld the trial court's ruling that barred him from accessing the Samburu County government offices without the prior written authorization of the Chief Executive Officer of the investigative agency, EACC. The appellant was charged in the anti-corruption case number 3 of 2019 with 4 counts under the Anti-Corruption and Economic Crimes Act. Under count 1, he was charged together with 13 others for the offense of conspiracy to commit an offense of corruption contrary to section 47A(3) as read in section 48 subsection 1 of the Anti-Corruption and Economic Crimes Act. Under count 3, for the offense of conflict of interest contrary to section 42(3 as read with section 48(1) of the Anti-Corruption and Economic Crimes Act. And under count 4, with the offense of unlawful acquisition of public property worth 84,695,996.55 cents, contrary to section 45(1)(a as read with section 48(1) of the Act, the Anti-Corruption and Economic Crimes Act. The offences were alleged to have been committed between 27th March and 25th March, during which period the appellant was the governor of Samburu County. Upon arraignment in court on 2nd April 2019, Honorable Ogoti granted the bail on interim terms, and thereafter, following the trial court's directions, the prosecution filed a notice of motion dated 16th April 2019, seeking an order to bar the appellant from accessing the Samburu County offices until the trial was determined. The trial magistrate, Honorable Murigi, upheld Honorable Ogoti's decision, save to vary the terms in the following manner. I quote, "The first respondent, who is the governor of Samburu County, is barred from accessing the Samburu County government offices without the prior written authorization from the CEO of the investigative agency, the EACC, who shall put measures, if any, in place so as to ensure that there is no contact between the first respondent with the prosecution witnesses and preserve the evidence until further orders of this court." End of quote. The appellant was aggrieved, and by a letter from his advocates, V.A. Nyamodi and Company Advocates, dated 3rd June 2019, the appellant sought a revision of that order in the High Court, arguing on 3 fronts. Firstly, that the appellant was the duly elected governor of Samburu County by virtue of Article 180 of the Constitution and was a constitutional office holder within the meaning of Section 62(6) of the Act, that he can therefore only be removed from his office on grounds provided for under Article 181(1) of the Constitution and pursuant to the procedure set out under Section 33 of the County Government Act. It was his contention that the impugned order of the trial court that barred him, a constitutional office holder, from accessing the offices of the county government of Samburu without written authorization from the Chief Executive Officer of the EACC was tantamount to removing the appellant from office and was unconstitutional and unlawful. After hearing the parties' submissions, the learned judge, Judge Mumbi Ngogi, declined to exercise the court's powers of revision over the decision of the trial court and instead determined that in the public interest, the bail terms pertaining to access to the county offices by the appellant for the duration of the trial should remain in force. In considering the allegation that the governor was being removed from office, the learned judge stated, I quote, "The governor in this case is not being removed from office. He has been charged with an offense under the assessor and in my view, a proper reading of section of the Act requires that he does not continue to perform the functions of the office of governor while the criminal charges against him are pending. However, if section 62(6), which in my view violates the letter and spirit of the Constitution, particularly Chapter 6 on leadership and integrity, is to be given an interpretation that protects the applicant's access to his office, then conditions must be imposed that protect that interest. This is what the trial court, in my view, did in making the order requiring that the applicant obtains authorization of the CEO of the EACC before accessing his office. In the circumstances, I'm not satisfied that there has been an error of law that requires that this court revises the said order, and I accordingly decline to do so. End of quote. The appellant was dissatisfied with the decision and filed the present appeal against the decision of the High Court. During the hearing, Mr. Nyamodi, learned counsel for the appellant, gave a brief background to the appeal. Mr. Nyamodi, learned counsel for the appellant, submitted that the appellant was duly elected as governor for Samburu County on 8th August 2017. He was arrested and arraigned in court on 2nd April 2019 and had pleaded not guilty to the 4 counts under the Act. But when the issue of bail arose, the prosecution did not oppose it. That the Chief Magistrate, Honorable Ongoti's ruling found the county offices to be a scene of crime and barred the appellant from going to the offices without the prior authorization of the Director of Public Prosecution, the DPP. A formal application was subsequently made, though a ruling, not on record, where Honorable Murugi ordered that the appellant be barred from accessing the offices without the authority of the CEO of EACC. That it was that ruling that prompted the revision before the High Court. Counsel sought to argue the grounds under 6 heads. Counsel submitted that the court failed to assess the effect of the trial court's restrictive orders. It was asserted that the 2 stringent restrictions placed in the governor's way, namely the bond of Kenya shillings 150 million or cash bail of Kenya shillings 100 million, and the order barring him from accessing his office without authorization from the CEO of EACC, were clearly intended to lock him out of his office and were therefore unconstitutional and unlawful. On his part, Mr. Muteti, Senior Assistant Director of Public Prosecutions, adopted his written submissions and submitted that the learned judge considered all the relevant issues and applied the test of rationality, reasonableness, correctness, and legality. Addressing the question of whether the learned judge introduced new issues, counsel asserted that the learned judge analyzed the record and the submissions and rendered a decision that was in accordance with the matters raised. We have considered the parties' submissions and are of the view that central to this appeal is the issue of whether the learned judge rightly exercised her discretion to decline to review the bail and bond terms ordered by the trial court. In determining this issue, we are guided by the principles espoused in the established case of Gogo versus Shah, and alongside the question of whether the courts below properly exercised their discretion, we have been called upon to ascertain whether the interpretation of the relevant provisions was in accordance with the requirements of the Constitution. In doing so, courts are obliged to apply the principles aptly set out in the case of Kigula and others versus the AG in the following terms. The principles applicable in the interpretation of the Constitution include the widest construction possible in its context. Should be given according to the ordinary meaning of the words used. The entire Constitution has to be read as an integrated whole, and no one particular provision destroying the other. All provisions bearing on a particular issue should be considered together to give effect to the purpose of the instrument. The Constitution should be given a generous and purposive interpretation to realize the full benefit of the guaranteed rights. The Constitution of Uganda enjoins courts in the country to exercise judicial power in conformity with the law and with the values and norms and aspirations of the people. That particular authority is from Uganda. Beginning with whether the learned judge wrongly concluded that Section 62(6) of the Act was unconstitutional, Section 62(1) provides that a public officer or state officer who is charged with corruption or economic crime shall be suspended at half pay with effect from the date of the charge until the conclusion of the case. The provision also provides that the case shall be determined within 24 months and the public officer ceases to be suspended if the proceedings against him are discontinued or if the public officer is acquitted. In opposition to Section 62(1), Section 62(6) stipulates that this section shall not apply with respect to an office if the Constitution limits or provides for the grounds upon which the holder of the office may be removed or the circumstances in which the office must be vacated. In the instant case, what is for determination is whether the bail terms imposed on the appellant were unconstitutional, unreasonable, and unlawful because they were applied without appreciation of the mandatory requirements of Section 62(6). After having been urged to apply the finding of the High Court, where similar terms were imposed in the case of Mohammed Abdallah Swazuri and 16 others versus Republic, to the effect that there was a conflict of interest between the National Land Commission and the CEO of EACC, the learned judge determined the question of access by the governor to his office from a different perspective. In considering Section 62(6) to be against the national values and principles of governance, as well as the principles of leadership and integrity in Chapter 6, the learned judge stated as follows: in my view, a proper reading of Section 62 of the Act requires that he does not continue to perform the functions of the office of governor while the criminal charges against him are pending. However, if Section 62(6), which in my view violates the letter and spirit of the Constitution, particularly Chapter 6 on leadership and integrity, is to be given an interpretation that protects the applicant's access to his office, then conditions must be imposed that protect the public interest." End of quote. In the court's view, this is what led the trial court to order the bail terms which barred the appellant from accessing the county offices without authorization of the CEO of EACC. We will return to the issue of constitutionality or not of the bail terms shortly. The statement above quoted is what Mr. Nyamodi has contended was the learned judge's declaration of the Section 62(6) to be unconstitutional. But our analysis of the statement does not lead us to that conclusion. Indeed, we find that the statement cannot in any way be interpreted or construed as a declaration of Section 62(6) to be unconstitutional. The learned judge merely remarked that the provision stands against the intent and purport behind the leadership and integrity provisions of the Constitution and stopped there. The court did not then proceed to declare or hold the provision unconstitutional. On this question, it should be appreciated that a finding of any legislation to be unconstitutional is not a matter to be taken lightly. It involves a definitive process initiated either through a petition to Parliament under Article 119(1) or upon the placing of a substantive issue of interpretation to the effect that the provision is inconsistent with or in contravention of the Constitution before the High Court, which under Article 165 3D1 is endowed with that mandate, or any court of competent jurisdiction. As observed by the appellant's counsel, no such question was placed before the court, and from a reading of the ruling, no determination of that nature was made in respect of the impugned provision. Consequently, we are satisfied that the learned judge did not declare Section 62(6) to be unconstitutional. So was the learned judge wrong to decline to apply Section 62(6) to the circumstances of this case? Again, our reading of the ruling does not lead us to such summation. Addressing the question of whether the provision on removal from office, that is Article 181, when read with Section 62(6), inferred that, despite the corruption charges for alleged abuse or misuse of their offices to the detriment of the public, such state officers should remain in office. The learned judge observed that that was not the intent or purport of Section 62(6), particularly when the impugned provision was considered alongside Article 49(1) subsection H, which allows courts to grant bail on reasonable terms. On the basis that the application was grounded on Article 49(1)H, the judge concluded that Section 62(6) was irrelevant to the instant case. In so finding, the High Court held that the trial court was entitled to apply the bail terms it did, including one which barred the governor from accessing the county offices. Determining whether or not Section 62(6) was applicable requires that the genesis of the application be considered. The application for review in the High Court arose from a bail application in the trial court, which the respondent did not oppose, but nevertheless requested for the imposition of stringent bail conditions on the appellant. Article 49(1)H of the Constitution allows the trial court to impose bail terms. Section 62(6) prohibits application of Section 62(1) in the case of a constitutional office holder charged with a corruption offense, where the Constitution already provides a method for removal, which in this case is Article 181. When these provisions are considered against Article 49(1)H, which allows for imposition of reasonable bail terms, it becomes patently clear that they address two disparate circumstances. One is concerned with removal from office, and the other, imposition of bail. The complaint is that denying the appellant access to the county offices during the period of the trial was tantamount to his removal from office as contemplated by Article 181, and hence contrary to the requirements of Section 62(6). But limiting the governor's access to the county offices while he is facing trial for corruption offenses cannot be construed or equated to a removal from office. The governor has not been ordered to vacate his office. He may access his office, but on the conditions imposed by the court. Though his access is limited, he remains the governor. Given the aforegoing, our view is that the allegation that the imposition of bail terms barring the appellant from the county offices was tantamount to a removal from office is therefore unfounded. As such, we agree with the High Court that application of Section 62(6) was unnecessary, and the learned judge was not compelled to apply that provision to the circumstances of this case. Of greater relevance, perhaps, is a question of whether the bail terms that barred the appellant from office or subjecting the county government to the control of EACC was reasonable. This brings us to the next issue of the reasonableness or otherwise of the bail terms. As already seen above, Article 49(1)H allows the trial court to impose bail terms. In addition, Section 183 of the Criminal Procedure Code is relevant. Essentially, both the Constitution and the law stipulate that an arrested person may be released on bond or bail on reasonable conditions. And in granting bail or bond to an accused person, it must be borne in mind that the court is being called upon to exercise its discretion. In such exercise, the court is guided by certain well-established principles, such as those enumerated in the case of Republic versus Pascal Ucheng Lawrence, where it was stated, I quote, "It is to be noted that unlike in the past, when an accused person had to demonstrate why he should be released on bail or bond, that duty now properly belongs to the state. The court, in exercising its discretion as to whether or not to grant bond, is however to be guided by the following parameters: the seriousness of the offense, although this carried greater weight under the old constitutional dispensation; 2, the weight of the evidence so far adduced if the case is partly heard; 3, the possibility of the accused interfering with witnesses; the safety and protection of the accused once he or she is released on bail or bond; and whether the accused will turn up for trial, whether the release of the accused will jeopardize the security of the community. Having found, as we have, that the bail terms did not offend Article 181 or Section 62(6), we also observe that no other reasons were advanced to demonstrate that the bail conditions imposed were unconstitutional and reasonable or unattainable. So that in granting bail on the conditions it did, it is evident to us that, after appreciating the nature of the corruption charges preferred and considering the possibility of witness interference or suppression or tampering with evidence, which, as seen herein above, are the usual criteria a court may take into account, the trial court imposed the impugned bail terms. In addition to the above, and contrary to the appellant's assertion that the learned judge introduced new arguments, both courts below acceded to the dictates of Article 10(1)(b) of the Constitution and took into account the imperatives of Chapter 6 of the Constitution on leadership and integrity and other public interest elements of the Constitution, and arrived at bail terms that were reasonable and constitutional. In observing that the safeguarding of public interest was an essential requirement in such cases, the High Court found that the bail terms imposed were sufficient and concluded that no error or misdirection had been made on the trial court's part. Likewise, we too are satisfied that both courts below properly exercised their discretion when they took into account the appropriate principles or guidelines on bail. Further, we can find no wrong in the two courts' application of the national values and constitutional imperatives set out in Chapter 6 of the Constitution to arrive at bail terms imposed. After all, under both Articles 10(1)(b) and 259(1) of the Constitution, courts are duty-bound to take into account the national values, principles of governance, and the Chapter 6 principles on leadership and integrity when applying provisions of the Constitution. We need go no further than to cite the Supreme Court decision on the issue as enumerated in the matter of the Interim Independent Electoral Commission constitutional application, where it embraced the sentiments of Justice in the Namibian case of State versus Acheson, which stated, I quote, "The constitution of a nation is not simply a statute which mechanically defines the structures of government and the relationship of government and the governed. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values bonding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. Lastly, and fundamentally, it is a principle that the provisions of the Constitution must be read as an integrated whole, without any one particular provision destroying the other, but each sustaining the other." End of quote. Fortified by the above, our view is that the judge's application of the constitutional imperatives and the public interest factor were not newly introduced issues, but were applicable criteria to the circumstances of this case, and we so find. On this basis, we find that the bail terms were constitutional and lawful. Turning to the question of subordination of the appellant and the county offices to the CEO of the EACC, as highlighted in the Swazuri's case, which has been indicated above, much as there will be a measure of inconvenience to the appellant in accessing the county offices, it is recognized that the bail terms imposed are intended to eliminate the possibility of witness interference and evidence tampering. In exchange for the granting of bail, as did the High Court, we see this as a necessary intervention for the effective enforcement of the court's orders. Furthermore, on the complaint that the learned judge failed to consider the impact of the ruling on the county government of Samburu, this is what the learned judge had to say. First, I consider what the implications of directing that the applicant does not access his office. This is provided for in Section 32(2) of the County Governments Act, which states that the deputy governor shall deputize for the governor in the execution of the governor's functions. End of quote. The learned judge went on to state that therefore there would be no vacuum in the county offices, and that there have been instances where, due to ill health, the governor has been unable to attend to their duties, and that given the fact that the Constitution provides for the seat of deputy governor, the counties have continued to function. We would agree, having found as we have that the bail terms did not remove the appellant from office, but merely required compliance with the constitutionality sanctioned terms that of necessity limited his access to the county offices until determination of the trial, we find that the learned judge sufficiently addressed the issues of pointing out the relevant constitutionally crafted remedy. All issues considered, we are satisfied that the learned judge determined and analyzed only matters that were placed before her. And as we have found no misdirection in the exercise of discretion, we have no basis upon which to interfere with the High Court's decision. In sum, the appeal is unmerited and is for dismissal with costs to the respondent. It is so ordered. Of 2019. The first count against the appellant was conflict of interest. Contrary to Section 42(3, as read with Section 48 of the Anti-Corruption and Economic Crimes Act, 2003. The particulars of the offense were that between 2nd July 2018 and 13th March 2019, at Kiambu County, the appellant knowingly acquired an indirect private interest, to wit, receipt of Kenya shillings 25,624,500 in respect of payments made to Testimony Enterprises Limited for contracts awarded to the said company by the Kiambu County government. In the second count, the appellant faced a charge of dealing with suspect property, contrary to Section 47(1, as read with Section 47(2)(a) and 48 of the Anti-Corruption and Economic Crimes Act, hereinafter the Act. The particulars of the offense were that between 2nd July 2018 and 13th March 2019, in Nairobi, the appellant and Saika 2 Estate Developers Limited, a company associated with the appellant, received Kenya shillings 18,410,500 from Testimony Enterprises Limited, having reason to believe that the said amount was acquired from Kiambu County government through corrupt conduct. The third count was against the appellant and his wife, Susan Wangari Ndongo, trading as Bienven Delta Hotel, was dealing with suspect property contrary to Section 47(1, as read with Section 47(2)(a) and 48 of the Anti-Corruption and Economic Crimes Act. The two are alleged to have received Kenya shillings 7,214,000 from Testimony Enterprises, while having reason to believe that the said amount was acquired from Kiambu County government through corrupt conduct. The appellant denied the said charges, and through his counsel, Professor Tom Ojienda, Senior Counsel, sought to be admitted to bail bond. The Director of Public Prosecutions, the DPP, through Mr. Alexander Buteti and Mr. Vincent Monda, Senior Assistant Directors of Public Prosecution, did not oppose the application, but urged the trial court to impose certain conditions for the appellant's release on bail. The appellant strongly opposed the suggested terms of his admission to bail or bond, particularly the first one, which was that the appellant to be barred from going back to the office pending determination of the criminal case, arguing that imposing such conditions would amount to a violation of Article 49(1)(h) of the Constitution and Section 62(6) of the Act, and was tantamount to unlawfully removing him from office. In a considered ruling, the trial court ordered release of the appellant on a cash bail of Kenya shillings 15 million, in the alternative, bond of Kenya shillings 30 million, plus one surety of a like amount. In addition, the trial court ordered that the appellant shall not access his office until the criminal case is heard and determined. The appellant was also ordered to deposit his travel documents with the court. The appellant, and indeed all his co-accused, were further ordered not to contact witnesses or interfere with prosecution exhibits or any other evidence. Being aggrieved by the orders made by the trial court on 30th July 2019, Professor Ojienda, on behalf of the appellant, wrote to the Deputy Registrar of the Anti-Corruption and Economic Crimes Division of the High Court, requesting for revision of the trial court's order relating to the bail and bond terms. He stated inter alia that the bail and bond terms are excessive issued per incurium, and the terms amount to a constructive denial of bail and bond without compelling reasons. He filed submissions and a list of authorities in support of the application for revision. The DPP opposed the application for revision of the trial court's decision and filed grounds of opposition, stating inter alia that it offends the provisions of section 364(5) of the Criminal Procedure Code in that the applicant ought to have filed an appeal, that the applicant was seeking interpretation of various constitutional questions, a jurisdiction that is a preserve of the High Court, sitting as a constitutional court, and that the bail terms met the threshold set out under Article 49 of the Constitution, and therefore there was no justification for the High Court's intervention. In her ruling, Justice Ngenya Macharia flagged 3 issues for determination. 1, whether the court had jurisdiction to entertain the application. 2, whether the learned trial magistrate erred in imposing a condition to the bail terms that the appellant should not set foot in his office pending the hearing and determination of the trial. And 3, whether the bail terms imposed were harsh and excessive. Regarding the first issue, the court held that it had a supervisory jurisdiction over decisions made by the subordinate court under sections 362 and 364 of the Criminal Procedure Code and articles 165(6) and 7 of the Constitution. On the second issue, requiring the appellant to keep off his office during the pendency of the criminal case, the learned judge held that attaching conditions to the grant of bail is not tantamount to a removal of the governor from office. As to whether the other bail terms imposed on the appellant and his co-accused were harsh and excessive, the learned judge found that the amount of Kenya shillings 15 million cash bail or bond of Kenya shillings 30 million with a surety of similar amount was appropriate. Being dissatisfied with the High Court ruling, the appellant preferred this appeal, raising 16 grounds of appeal in his memorandum of appeal. However, in his written submissions, the appellant's learned counsel condensed the issues that fall for determination by this court into 2. 1, whether the finding of the learned judge that the order of the learned trial magistrate directing the appellant not to set foot in his office until his trial is heard and determined did not amount to his removal from office and violated the Constitution. 2, whether the finding of the learned judge that the bail granted to the appellant by the learned trial magistrate of cash Kenya shillings 15 million or a bond of 30 million with a surety of a similar amount was appropriate and neither harsh nor excessive for charges of amounts totaling a sum of Kenya shillings 51,249,000 was correct. When the appeal came up for hearing, the appellant was represented by Professor Tom Ojienda, Senior Counsel, Honorable G. Imanyara, N. Harvey, Siki Prono, and K. Oriri. The respondent was represented by Alexander Muteti and Vincent Monda, Alex Akula, and Wesley Nyamache, Senior Prosecution Counsel. Both parties relied on their written submissions and various authorities, which they briefly highlighted. Professor Ojienda submitted that this court has jurisdiction to hear and grant the order sought in this appeal, arguing that relief sought on the substantive issues do not avail in the jurisdiction under Rule 59 of the Court of Appeal Rules, which requires the applicant, which requires an appellant before filing an appeal to file a notice of appeal stating the nature of the acquittal, conviction, sentence, or finding against which it is desired to appeal. Counsel stated that under Rule 52A of this court's rules, this court is empowered to grant interlocutory reliefs in order to preserve the substance of an appeal, in this case, to secure the liberty of the appellant. The appellant had filed a notice of appeal against a ruling of the High Court. Counsel cited this court's decision in Thomas Patrick Gilbert Chomley versus Republic, where the appellant appealed against the decision of the trial court that he had a case to answer. The appeal before this court is neither purely civil nor purely criminal in nature. it raises constitutional issues that are weighty, Council submitted. He cited the Supreme Court decision in Dines Muriithi and 4 others versus Law Society of Kenya, where a question was brought as to whether the Court of Appeal has jurisdiction to issue orders under Rule 52B of its rules when the appeal is neither purely civil nor purely criminal. The Supreme Court held, at paragraph 36, it is thus not the case that the Court of Appeal lacked jurisdiction to issue orders in the Rule 52B application, just because the matter is sui generis and is constitutional in nature, and neither civil nor criminal. The High Court has already, quite properly, taken the position that it is unnecessary to bring such special matters under a wholly novel regime of procedural law. At paragraph 37, the Supreme Court stated, it is evident to us that appeals dealing with constitutional issues may in substance be civil in nature. Accordingly, the Court of Appeal has the power to exercise its original and discretionary jurisdiction to entertain interlocutory applications to preserve the subject matter of any appeals. End of quote. Professor Ojienda urged this court to find and hold that it has jurisdiction to hear and determine this appeal. Turning to the question whether the finding of the learned judge that the trial court's order directing the appellant not to set foot in his office until his trial is heard amounted to his removal from office and violated the Constitution, Council cited the provisions of Section 30 and 31 of the County Governments Act that set out the functions and responsibilities of a county governor and his powers respectively. Professor Ojienda submitted that in the case of Mohammed Abdallah Swazuri and 16 others, the High Court did not find any unconstitutionality in the provisions of Section 62(6) of the Act and urged the court to find that the learned judge erred in her interpretation of that section. On the last issue, it was submitted that the appellant's request for revision of the terms of bail and bond was based on the provisions of Articles 49H and 52 and 50, subarticle 2A of the Constitution. For stated reasons, the court was urged to allow the appeal, set aside the High Court ruling, allow the appellant to access his office and discharge his constitutional functions, and reduce the cash bail from 15 million to Kenya shillings 2 million or a bond of Kenya shillings 5 million. The DPP opposed the appeal. He filed submissions and a bundle of authorities that were highlighted by Mr. Monda. He started by pointing out that the appeal is incurably defective, as it is based on wrong rules, that the appellant had filed a civil appeal, whereas both the decision of the trial magistrate and that of the High Court are purely criminal matters. Consequently, this court does not have jurisdiction to entertain the appeal. Council urged the court to interpret the Constitution and Section 62 of the Act wholesomely and in a manner that brings life to the Constitution and development of the law. Lastly, regarding the other terms that were imposed by the trial court in granting bail to the appellant and which were affirmed by the High Court, Mr. Monda submitted that they were fair and reasonable, and the court struck the right balance between the appellant's personal interest and public interest. In any event, Council added, no evidence was placed before the court to show that the appellant had encountered any difficulties in complying with the imposed condition. With that, we were urged to dismiss the appeal in its entirety. On the question of jurisdiction, following delivery of the impugned ruling on 8 August 2019, the appellant, through Professor Ojienda, filed a notice of appeal under Rule 75 of the Court of Appeal Rules. Rule 75 requires any person who desires to appeal to the court to give notice in writing within 14 14 days of the date of the decision against which it is desired to appeal. Part 3 of the Court of Appeal rules is the one that deals with criminal appeals. Rule 59 requires any person who desires to file a criminal appeal to give notice within 14 days of the date of the decision sought to appeal from. The notice should state the nature of the acquittal, conviction, sentence, or finding against which it is desired to appeal. Ordinarily, in criminal matters, there are no interlocutory appeals. Appeals are filed only after the final determination of a case. The DPP urged us to find that this court has no jurisdiction to entertain the appeal as instituted and strike it out. On the other hand, the Appellant's Counsel submitted that this is a sui generis appeal, as it is neither criminal nor civil in nature. It largely relates to interpretation of various constitutional and statutory provisions, and therefore we have no jurisdiction to entertain it as a civil appeal, even if the initial case before the trial court is a criminal case and the matter before the High Court was instituted as criminal revision. We must ask ourselves, how then did the case metamorphose from a criminal matter to a civil one? Why was it not filed as a criminal appeal, as in the case of Thomas Patrick Chomley? We do not have any answer to these questions, and neither did the Appellant's Learned Counsel shed any light. While we do not encourage this kind of practice, we note that the Supreme Court stated in the case of Dines Mureithi and 4 others versus the Law Society of Kenya that appeals dealing with constitutional issues may in substance be civil in nature. Further, we think that to decline jurisdiction and strike out the appeal simply because it was not instituted as a criminal appeal would be tantamount to summary rejection of the appeal on a matter of form rather than substance, which should be contrary to the spirit and intent of Article 159(2)(d) of the Constitution. On the question of denial of access to his office, did it amount to removal of the appellant from office? The trial magistrate held that barring the appellant from accessing his office neither violated the Constitution nor amounted to his removal from office. It was only, intended to ensure the integrity and credibility of this trial and to ensure the public interest is safeguarded, end of quote. The learned judge concurred with the trial magistrate. We have already quoted her sentiments on the issue. On the other hand, Professor Ojienda argued that the learned judge's holding amounted to a constructive removal and or suspension of the appellant as the governor of Kiambu County. He cited Black's Law Dictionary, 10th edition, which defines office as a position of duty, trust, or authority for public purpose, a place where business is conducted or services are performed. The same dictionary defines removal as the immediate termination of an office holder's privilege to serve in that office, usually after a vote. Suspension is defined to mean the temporary deprivation of a person's powers or privileges, especially of office or profession. It also includes temporary withdrawal from employment as distinguished from permanent severance. Counsel submitted that the effect of the trial court's orders that were affirmed by the High Court was to occasion an unlawful vacancy in the office of Governor of Kiambu County, which is contrary to the provisions of Article 182(1) of the Constitution. The article stipulates that the office of Governor falls vacant when the holder thereof dies, resigns in writing, addressed to the Speaker of the County Assembly, ceases to be eligible to be elected County Governor under Article 180, Sub-Article 2, is convicted of an offense punishable by imprisonment for at least 12 months, or is removed from office under the Constitution. He concluded by saying that there is absolutely no provision of law that empowers a court to occasion a vacancy in the office of a governor through the imposition of bail terms and conditions. The determination of this issue involved interpretation of Articles 49(1)(h), 181 and 182 of the Constitution, as well as Section 62(6) of the Act. The learned judge had that in mind and stated, quote, Since the Constitution provides for mechanisms of removal or vacating such state officers, no other law would supersede it." End of quote. She then considered the provisions of Article 181 and 182 of the Constitution that relate to removal of a county governor and vacancy that office respectively, and concluded as follows. This court, having aligned itself to the supremacy of the Constitution, holds that attaching conditions to the grant of bail is not tantamount to a removal of the governor from office. We do not think that the learned judge can be faulted for arriving at that conclusion. Article 49(1)(h) of the Constitution provides that an arrested person has a right to be released on bond or bail on reasonable conditions, pending a charge or trial, unless there are compelling reasons not to be released. In our view, to the extent that neither the trial magistrate nor the learned judge's holding purported to remove or suspend the appellant from office of governor, Kiambu County, Section 62(6) of the Act had no application in the matter that was before her. The appellant has not been suspended from his office. He is still the governor of Kiambu County. He is still entitled to his full pay, not half. In the circumstances, the learned judge cannot be accused of having failed to apply the omitted case, canon of statutory interpretation, in affirming the terms of the appellant's grant of bail. The issue of constitutionality or otherwise of Section 62(6) of the Act is not before us for determination in this appeal, and therefore we cannot express any opinion on the same. Regarding the conditions attached to the grant of bail by the trial court, the learned judge was of the view that the trial court wanted to ensure that the relationship between the appellant and potential witnesses does not undermine the interests of justice. Article 49(1)(h) of the Constitution grants an accused person the right to be released on bond or bail on reasonable terms and conditions pending trial, unless there are compelling reasons not to be released. The bail and bond policy guidelines formulated by the judiciary require courts in granting bail to take into consideration, inter alia, the facts and circumstances of each case, and to balance the rights of an accused person against the interests of justice. The same considerations are applicable to all accused persons, irrespective of their society in standing, irrespective of their standing in society. In Republic versus Zachariah Okoth Obado, the accused is the governor of Migori County and was charged with murder. Among the conditions for his release on bail were that he shall not go anywhere within 20 kilometers of Homa Bay Migori border. He shall report once a month to the High Court's Deputy Registrar, and that he shall not contact or intimidate, whether directly or indirectly, any of the prosecution witnesses. In the case of the appellant, bearing in mind the nature of the charges preferred against him, the circumstances under which the alleged offenses were committed, that some of the prosecution witnesses are county staff who are answerable to the appellant, it was not far-fetched for the prosecution to contend that the appellant would most likely interfere with their witnesses or conduct himself in a manner likely to compromise their case if he was not barred from accessing his office during the pendency of the case. There are documented incidents of loss and or disappearance of vital documents from certain offices where public or state officers charged with corruption or economic crimes related to their work have been allowed unrestricted access to their offices during the pendency of the cases. Looking at the statutory functions and responsibilities of a county governor, the structure of governance, and the legislative and administrative institutions of a county, we do not think the impugned bail terms, unless set aside, are likely to paralyze the operations of Kiambu County, as was submitted by the appellant's learned counsel. The question of whether Kenya shillings 15 million cash bail or bond, or Kenya shillings 30 million with a surety of a similar amount, was harsh and excessive, the appellant argued that the above terms are set out by the trial court and affirmed by the High Court are harsh and excessive, unreasonable, contrary to Article 49(1)(h) and Sections 123 and 123A of the Criminal Procedure Code. The judiciary bail and bond policy guidelines and were fixed without regard to the circumstances of the case and evaluation of the nature or seriousness of the case, the character, antecedents, associations, and community ties of the appellant's record in respect of the fulfillment of obligations under previous grants of bail, and the strength of the evidence of the appellant having committed the offense. The learned judge found the bail bond sums imposed by the trial court appropriate. The learned judge held that the grant of bail by the trial court was an exercise of discretion, and the High Court could only interfere if the decision was shown to be plainly wrong or granted without consideration of relevant factors. The learned judge stated, and I quote, "The court was under a duty to consider the grant of bail for each individual accused person, examine their circumstances before setting commensurate bond or bail terms and attaching conditions. It is right that the setting of bond or bail amounts is an exercise of discretion by the trial court, and before interfering with that exercise, this court must be cautious, as was ably enunciated by Baroness Hale, as she then was, in the case of J, a child, a 2006 case that stated that if there is indeed a discretion in which several factors are relevant, the evaluation and balancing of those factors is a matter for the trial magistrate. Only if his decision is so plainly wrong that he must have given far too much weight to a particular factor is the appellate court entitled to interfere. Too ready an interference by the appellate court risks robbing the trial magistrate of the discretion entrusted to him by law." End of quote. We respectively agree with the learned judge's holding, and we have no basis of faulting her in any way. In conclusion, therefore, we find this appeal devoid of merit and dismiss it in its entirety. The appellant shall bear the costs of the appeal. It is so ordered.